Welcome back. I'm excited for this next session at 11 o'clock. Just a friendly reminder for participants to type your questions in the chat at the end of the session, and our media specialist, Jason Harper, will read the questions off to the presenters in the order they are received. Our 11 o'clock session brings two experts in the field. Please welcome Dicky Shanor, WDE Chief of Staff, and Doug Bailey, partner and attorney for Bailey, Stock, Harmon, Cottam, and Lopez. Gentlemen, take it away.
Thank you.
Thank you. Thanks, Kim. As she said, this is Dicky Shanor with the Department of Ed, and I'm joined by Cheyenne attorney Doug Bailey. And we are excited to present to you today on Wyoming House Bill 147. So we wanted to start with just a disclaimer that we are not offering legal advice today. We're simply doing an overview of the law itself and related federal activity to this topic. And that if you have a specific issue that you're trying to address, either at your local government or in some other facet of your life, that you really need to consult your own attorney and not rely on this presentation today. Next slide.
All right. Thank you, Dicky. Let's get started, and thank you everybody for being here today. We're going to talk about House Bill 147, what it is and how it came to be. It
It looks like maybe we are
I
going to refresh. Doug,
did, okay.
oh,
I was
go
gonna ask
ahead.
you. Yeah, I was gonna ask if his screen froze.
Yeah. Yep. And
Okay.
it looks like he is going to hop off and hop back on. Thank you, everyone, for hanging with us.
Kim, while we're waiting for him to hop back in, I'll just keep going if that's okay with you.
Okay, that's wonderful. Thank you, Dicky.
Okay. So, House Bill 147 was passed during the 2025 general session, which was last year, and it was signed into law by Governor Gordon at the end, near the end of that session on March 4th. And what it does is it prohibits what is commonly referred to as DEI in governmental entities in Wyoming. So, a state agency, a local agency, the University of Wyoming, a school district, et cetera, all the governmental entities this law applies to. And at the time, there for several years, nationally and statewide, it was a pretty hot topic, this discussion, particularly at the University of Wyoming, when they had a DEI office that was eventually closed in 2024 because of the controversy surrounding it. And then this bill passed the year after in the Wyoming legislature. So this is, as I said, it's a national issue. So you can see that Idaho is the first state that we've identified that passed sort of a divisive concepts DEI type bill in 2021, where they made it illegal for schools to require students to affirm any sort of inherent superiority or inferiority of one race or sex over another. And over time, over the last 5 years, 20 states have passed similar laws with varying definitions and enforcement mechanisms to the one we have in Wyoming. And you can go to the next slide. All right, so what's really important about this bill is that it defines the term because we so often hear, well, what is DEI or it's not DEI. You know, there's a lot of argument about what and what isn't DEI. So this bill made the effort to explicitly define what DEI is in a number of ways. So first, it says the definition of diversity, equity, or inclusion means any program, activity, or policy that promotes differential or preferential treatment of individuals or classifies individuals on the basis of race, color, religion, sex, ethnicity, or national origin. So that's language from federal civil rights law. Really just think about it as immutable characteristics for the most part, and treating people differently based on those. And then second is the definition of a governmental entity. What does that mean? Well, it's any state, any department thereof, the university, any city, county, town, school district, community college, or political subdivision. Any governmental entity has to comply with this law. You can go next slide. Okay, and then this is where they get into a little more detail on what they intend to prohibit with this law, what they did prohibit with this law. So you can see there's a definition for something called institutional discrimination, and very similar to the DEI definition, but it goes into a little more detail and specific, as you can see here, A through H, on what exactly institutional discrimination would be. And I'll give you just a minute yourself to read that slide. And of course, we'll be providing these slide decks after the summit, but I don't want to read them all out to you out loud. So just take a minute, review them, because these are really important to understand the sort of types of activity that is prohibited under this law. All right, Kim, let's go to the next slide. Oh, there we go. All right, so then the law says that no government entity shall engage in any DEI activity or policy or program, which is that definition of DEI we already went over, or engage in institutional discrimination, which are those definitions we just went over, or require instruction that promotes institutional discrimination. So no lesson in a classroom or no HR required training along those lines. And then last, prohibited from requiring any student, employee, or contractor to attend or participate in any DEI program or training or institutional discrimination program or training. So those two definitions, DEI, institutional. And lastly here, this is a part of the law, and this was a result of the tribes advocating to the legislature about making sure that this bill did not prevent them from teaching their history and their culture as they deem appropriate as a sovereign entity. Those tribes requested this and were granted that by the legislature to exempt themselves from the law. And so that's the last piece of the Wyoming statute. And you can go to the next slide, Kim. So what I'm going to do next, because we don't have any Wyoming case law yet on this law, because it's so new, it's only been on the books for about a year. So the most informative thing to do is to take a look at what the federal courts, and particularly the Supreme Court, which is very relevant to Wyoming, and then also the Trump administration has taken some executive action on this topic as well. And so anytime a Wyoming state court, if they are going to be dealing with this law in some fashion, they are going to look to other states who might have case law on a similar law. And they're also going to look to the Supreme Court and the federal courts and how they've handled issues like this. So that's why we're going to go through a couple of the big cases right now. And the first that we're going to talk about is one you may have heard of because it was litigated for many, many years. And it's called Students for Fair Admissions versus Harvard. And the U.S. Supreme Court finally ruled on this issue in 2023. And so the facts of the situation were that there was a group of students, Asian and white students, who sued Harvard over its admissions process, saying that it violated Title VI of the Civil Rights Act by discriminating against Asian American and white applicants in favor of what was referred to as underrepresented minority applicants. Harvard admitted that it used race as one of many factors in admissions, but that it was adhering to previous Supreme Court cases on the topic, because this is something that has been litigated in the Supreme Court up to this case. And so along the way, Harvard, they won, I misspelled there, they won at the trial court level, and they also won at the First Circuit Court of Appeals, and then they appealed to the U.S. Supreme Court. Next slide. So when it hit the U.S. Supreme Court and they ruled in a 6-3 majority opinion, the Supreme Court ruled that the Harvard admissions program violated the Equal Protection Clause of the 14th Amendment of the U.S. Constitution. And in short, it was Harvard and the University of North Carolina had been joined into this lawsuit. They could not demonstrate that there was a compelling interest in a measurable way for their policy. They failed to avoid racial stereotypes, and they did not offer a logical endpoint for when race-based admissions would cease. So the court ruled in favor of the students. Now, I guess the group, they weren't actually students at Harvard because they were denied admission. But and then what I wanted to note here too, though, is a key distinction that to be aware of. It's that they did say there's nothing that prohibits a university from considering an applicant's discussion of how race affected that applicant's life, so long as the discussion is concretely tied to a quality of character or unique ability that the particular applicant can contribute to the university. So they still can look at race through that lens. And then at this time, what I'd like to do is we found a little short video summary of this case because it was such a high profile case. There's a lot of information out there on it that really kind of sums it up well.
So the Students for Fair Admissions case was brought against Harvard University and the University of North Carolina. And it argued that the use of race in college admissions was unconstitutional under the Equal Protection Clause of the 14th Amendment and Title VI. And it asked the court to overturn the Supreme Court's precedent in Grutter, which allowed for a limited use of race in college admissions. So this issue has been going to the Supreme Court for decades. And it keeps coming up because the Supreme Court both acknowledges some of the university's arguments, at the same time expresses concerns about the constitutional implications of allowing universities to discriminate against students based on their race. In the Grutter case, the Supreme Court recognized that diversity was a compelling state interest. At the same time, it also said that the harm caused by sorting students into racial categories and treating them differently was so great that these policies couldn't last forever, that they could be used in a limited duration. Students for Fair Admissions is a nonprofit organization representing Asian American students who had been rejected from Harvard and who were raising arguments that Harvard's admissions program, which considers race in the application process, treated them unfairly, that in order to increase certain demographic groups, you also had to decrease other demographic groups. Harvard is a private university. The protections of the 14th Amendment don't directly apply to Harvard, but they do through Title VI, which is a provision of the Civil Rights Act that says that any recipient of federal funds has to spend those funds in a manner that is not discriminatory, doesn't exclude anyone based on race. Harvard argued that their admissions policy was constitutional under Grutter, which had allowed for the consideration of race in college admissions. And Harvard had actually filed an amicus brief in the previous case, Bakke, where they described their admissions process as one that is holistic, that looks at race as one factor out of many. The Supreme Court relied on that argument in the Grutter case involving the University of Michigan Law School. And so Harvard's argument Students for Fair Admissions was that their policy had been recognized as one that was different from the unconstitutional policies that had been struck down by the Supreme Court in Bakke and Gratz. In a majority opinion by 6 justices, the court held that Harvard and the University of North Carolina had engaged in unconstitutional race discrimination in violation of Title VI and the Equal Protection Clause of the 14th Amendment. The dissenting justices argued that we couldn't have race-blind policies because we still live in a society that has discrimination today. They argued that race-conscious policies ultimately would help to promote racial harmony and integration. And as Justice Sotomayor once said, that some people need a leg up, they need some help, and that race-conscious policies were one way to do that. So the dissenting justices rejected the notion of a colorblind constitution. They believed that some forms of race-conscious policies were still necessary and that they would be producing goods, benefits for universities and for society. The majority opinion responded that under the Equal Protection Clause, regardless of what one's motives are, discrimination is discrimination, it's unlawful, and it is harmful. That it's not possible to have a race-conscious policy that, even if it's framed in terms of trying to help some groups, if it has an exclusionary effect on people based on their race who aren't the beneficiaries of those policies, that's still unconstitutional, and that it does impose harms on Americans based on their race.
Thanks, Amy. All right, so the next big Supreme Court case we're going to talk about is related to employment, because any governmental entity and their employment practices also has to follow this House Bill 147 law and can't be implementing discriminatory things either in performance evaluations or promotions or hiring. So this is a Supreme Court case stemming from the state of Ohio. And a heterosexual woman, Marlene Ames, worked for the Department of Youth Services. She was promoted. She was given a good performance review. And after over 10 years of service, she switched to a new supervisor who was gay in 2017 and applied for a higher level position in 2019, but was not selected. And then her supervisor told her to consider retirement. And then after that, she was even demoted and given a pay cut and put down to a clerical position. And at the same time, a 25-year-old gay male was promoted to her previous position. And then later that year, a gay woman was promoted to the higher level position she had applied for, but wasn't selected for. So all of these factors put together led Ames to file a discrimination lawsuit against her state department under Title VII of the Civil Rights Act, which deals with employment discrimination. And just like in the other case, the Harvard case, she lost at the district court trial level. She lost at the Sixth Circuit Court of Appeals. So then she took it to the U.S. Supreme Court. And we have a real 2-minute video here where you can hear directly from her on what the story is.
The Supreme Court will hear a case that could dramatically change how the courts look at discrimination claims in the workplace. A state government employee sued, arguing she was demoted because she is heterosexual. She spoke to Jan Crawford about the case.
Marlene Ames was working for the Ohio Department of Youth Services when a position opened up as bureau chief.
And then you decided to put in for promotion.
Yes. My supervisor at the time asked if I was going to apply.
But just a few days after she got her 30-year service pin, Ames found out instead of a promotion, she was being demoted to a secretary.
It was humiliating going to work every day.
The colleague who replaced her was gay, and shortly afterward, the promotion went to a woman who also was gay. Ames decided to sue for discrimination based on her sexual orientation as a straight woman.
I knew the law was against us. Took the case anyway.
Akron lawyer Edward Gilbert knew it was a tough fight because federal courts in Ohio, like those in about a third of the country, require people filing suit to jump through another hoop by proving, for example, a pattern of historical discrimination, a burden non-minority groups can't always show. After lower courts ruled against her, Gilbert connected with the University of Virginia Law School's Supreme Court litigation clinic.
The Civil Rights Act protects all of us, and it protects all of us equally. And to have judges put additional rules and burdens on people just isn't fair.
But some civil rights advocates are siding against Ames.
Discrimination is not a relic of the past,
saying the law was originally passed to protect Black people and other minorities, and evidence of historical discrimination is important.
LGBTQ plus people report much higher rates of discrimination in the workplace than other groups.
Ohio officials deny Ames's claims and say she was demoted as part of a broader restructuring of the department. But Ames says she didn't deserve what happened to her.
This is for everyone in the United States. Everyone should have a fair shake at their own battles.
The Biden administration and now the Trump administration are agreeing with Ames's arguments. She says the rules across the country should be the same so that she can try to prove her case at trial. Gail?
All right, Jan, thank you very much.
Thank you, Amy. All right, so you can see that when this case was finally decided by the Supreme Court, they ruled unanimously in Ames's favor. That's all conservatives and liberal judges. If you go back up to that, thanks. They ruled in favor of her, saying that the employer violated the Civil Rights Act. And the key thing in this case is leading up to this, there was this background circumstances rule, which relates to this concept of DEI, and where there were basically a different set of rules for how you could prove discrimination if you were a minority or a majority. And if you were a majority, in this case, Miss Ames, as a heterosexual, she was required to put forth this background circumstances test, which is sort of this added burden you heard that attorney refer to, where she had to prove that this employer was unusual in its discrimination and provide all this additional evidence that would not be required of someone in a minority situation. And the Supreme Court said, no, that's not appropriate. This act does not distinguish between majority and minority. It says if you discriminate based on someone's immutable characteristics, it's the same standard. And that's why I think that you saw a bipartisan, unanimous decision from the Supreme Court in this ruling. Okay, next we're going to switch over to Doug, and he's going to talk about the 3 executive orders and another case about those.
Great. Thank you, Dicky. Sorry for losing everybody. Had some issues with the internet at my house, but I'm back online coming at you from my iPad. And actually, I think it's kind of interesting that we're talking about these national cases and federal executive orders. It provides context, I think, to the Wyoming bill that we're going to be talking about here shortly. So President Trump, when he was elected, immediately focused in on this issue of diversity, equity, and inclusion, and he issued several executive orders. I have a little YouTube video that gives I guess, a summary of what these executive orders are. If we could click on that and play that Spectrum News clip.
Hang on, I'm getting it loaded.
Thank you.
We will forge a society that is colorblind and merit-based.
In his inaugural address, President Donald Trump signaled an end to diversity, equity, and inclusion programs across the federal government. Just hours later, Trump acted, signing an executive order scrapping all DEI programs within the federal government. The process moving quickly. This memo was sent to all federal agencies on Tuesday, giving them a deadline of 5 p.m. on Wednesday to close down any DEI offices, take down their websites and social media accounts, and put employees within them on paid administrative leave to either be laid off or reassigned to other roles. The memo also demanding that agencies cancel any DEI trainings and cut ties with any contractors that offer DEI services. The memo including this sample letter to be sent out to employees, reading in part, "These programs divided Americans by race, wasted taxpayer dollars, and resulted in shameful discrimination." Trump also revoked a series of executive orders promoting diversity in the workplace, including a 60-year-old order signed by President Lyndon B. Johnson in 1965, which imposes an anti-discrimination and affirmative action requirement on all federal contractors.
It was expected, but it's reprehensible.
Civil rights groups like the National Urban League now blasting the move.
Don't fall for the false argument that this is about the restoration of merit. What this is really about is saying that only some with merit deserve a chance.
The purge of DEI programs is just the first step in what's expected to be a gutting of equity programs. Trump's executive orders mandate a government-wide review of federal contracts and grants to ensure that they're compliant with Trump's anti-DEI views. Reaction on Capitol Hill falling along party lines.
This DEI leave is just another example of kind of cruelty and pettiness.
The best way to stop discriminating against people on the basis of race or gender is to stop discriminating against people on the basis of race and gender.
The memo suggests that there also may be attempts to, quote, disguise the programs by changing the descriptions for job titles and contractors, the memo urging workers to report it if they see DEI programs in the workforce. Reporting here at the White House, I'm Evan Kozloff, Spectrum News.
Okay, thank you. So I think that gives a nice summary, I guess, of the purpose of these executive orders. The three that we have highlighted on your screen are slightly different from each other. The first one, Executive Order 14151, it directs federal government agencies to end all DEI policies and preferences in the federal government. And so as part of this order, action was taken to eliminate these types of agencies and offices, stop the funding of a lot of these agencies and offices, stop all kinds of trainings, promulgation of policies that that give preference to certain people or groups based on race, sex, religion, things like that. Executive Order 14168 had more to do with giving preference to people based on gender ideology. And this one specifically said or defined sex as an immutable biological classification, rejecting the concept of fluid gender identity. And then it eliminated programs, policies, trainings based on that kind of gender ideology. And then you have Executive Order 14173, which really seeks to eliminate DEI, I guess, training practices, policies from the private sector. So these other ones really related to government offices and agencies promoting or funding DEI or gender ideology. EO or Executive Order 14173 was directed at the private sector, really encouraging the government to go after private entities, huge companies that utilize this kind of preferential treatment in violation of the Civil Rights Act. We can go to the next slide. Okay, so after Trump issued this trio of executive orders, the National Institute of Health issued some guidance saying that it would no longer fund research related to DEI. So the federal government poured millions and millions of dollars into research relating to DEI and gender ideology, And after Trump issued the executive orders, the National Institute of Health said, let's stop funding this type of research. They were sued by a group of researchers and doctors and unions that relied on this funding, understandably. So this type of research and these types of programs had been around for years and years, and they were not happy when the funding stopped. And so they sued the NIH. And in 2025, the U.S. District Court for the District of Massachusetts vacated the guidance documents and the grant termination decisions, basically saying that the NIH could not halt the funding to these programs. And then in 2025, the Court of Appeals for the First Circuit upheld basically the district court's determination. But the Supreme Court kind of split the baby in a way. The Supreme Court said that the NIH's guidance documents would remain vacated, but they paved the way for the NIH to terminate the research grants that it determined were inconsistent with the Trump administration's policies on DEI and gender identity. So it can get a little convoluted when we start talking about different levels of courts and what's allowed and what's not allowed. But basically, this decision states that this type of funding can be terminated. And I think it's a good segue into what has now happened in Wyoming. We see the big picture with what's happening nationally, what the courts have been doing with preferential treatment for types of groups, and then how it applies to Wyoming. Let's go back to, and assuming we haven't done this already while I was gone, but if we could go to slide 3. And am I right, Dicky? We have not covered these few slides?
No, I went through them when you were readjusting. But
you did go through them.
I did. Yep.
Oh, great. Okay.
Yep.
Okay. Well, at this point then, I do think that going over those national decisions helps to understand what happened in Wyoming. If there's any, well, should we go to the tribal exclusion then, or did you cover that as well?
We covered that as well. I think we should
Okay.
just go to the last slide and talk to him about kind of what you and I talked through in terms of like the chain of command in
Very
terms
good.
of these issues. When Doug and I were going over this, we know that you all probably have questions in terms of like, what do you do if you feel like something you're interacting with either personally or at school with your children or just in your community, there's a governmental entity doing something that might implicate this law. And the first thing is to get the facts. Don't just take someone's word for it. Get the facts, gather evidence, gather the document, gather the people that were there, whatever it is. And it's important to address it first at the level that it happened. So if it's a classroom and a teacher with a kid, talk to the kid, talk to the teacher. And then what this conference is about today is how to properly engage up that org chart if you're not getting where you think you need to get. So eventually, if you can't get where you need to get with that teacher, then you talk to an administrator and eventually a local school board of elected trustees. If it's a school district or if it's a government agency, you talk to the director, maybe a legislator eventually. And then ultimately, if you just feel like you continue to hit a brick wall, that's the time where you're going to want to consult your own private attorney. And also, I would offer too that if it's a school thing, the Department of Ed has the Attorney General's office to consult as well that we can reach out to with any issues that are impacting schools across the state. So with that, we're happy to try to answer any questions in the chat. Let's see. Okay, I don't see any.
If anybody has any questions, please type them in the chat and I will read them out to the panelists. Thank you.
Well, if we don't have any, that means everybody gets a longer lunch.
Excellent. Well, we just can't thank you guys enough, gentlemen, for coming on and sharing your expertise. I think that at this point, we will have a little extra time for lunch, and please join us back at 1 p.m. for another afternoon full of information, some good sessions coming up. And so with that, we will bid you adieu. Enjoy your lunch. Thank you.